Yeah, Your Honor, if we do have a resolution prior to October 13th, would we be able to get on your docket?
No. If there's a resolution, it'll be resolved on October 13th.
Okay, and there is no date that's sooner. I don't know that we need that much.
I said no. I need that much time. I need that much time. This is the court's docket. I need that much time. And the people are going to get 2 months to get the discovery to you. And then my docket says October the 13th.
Welcome back to another jaw-dropping day in court. Today's hearing has two very different defendants, and trust me, you're going to want to stick around for this roller coaster. First up, we've got Mr. Logan, whose lawyer is already clashing with the judge about discovery deadlines and scheduling. Sounds simple, right? But wait, because after that, things explode with Mr. McCrary, who decides he doesn't need a lawyer. He's going head-to-head with the judge, raising claims of judicial bias, and even challenging the very authority of the court itself. One case feels like legal housekeeping, the other? A courtroom showdown. Who's right, who's wrong, and who's just digging themselves into a deeper hole? Let's dive in.
Thurman Lagan Jr.
Thank you. Today is the day set for pretrial conference. How are we proceeding?
Your Honor, I inquire if Ms. Ritter is going to be handling this case next time, because I want to be able to communicate with her outside of court, give her additional information about my client, and also there's some additional discovery that I have not been tendered that I need to get.
She's my courtroom prosecutor. I'm not sure what you mean by is she going to be handling it next time? She's the prosecutor.
Yeah, what I'm asking is, well, I want to schedule for another pretrial, but I want to be able to contact her outside court, give her additional information about my client and about the situation.
Here's where we see the first spark of tension. The defense attorney is basically saying, "Hey judge, I need more time. Let's slow this down." This is pretty common. Defense lawyers often ask for adjournments to review discovery or gather more information. But watch closely, the judge has no problem granting a continuance, but she's firm about keeping control of the schedule. Judges juggle dozens of cases, so sticking to deadlines is critical. Quick question for you. Do you think the defense attorney was just being thorough, or trying to buy time because the case isn't strong? Drop your thoughts in the comments.
And be able to get the discovery that I need.
Okay, I mean, I think I answered your question, counsel. She's my courtroom prosecutor.
Okay. All right, Your Honor, what I'm asking for today is an adjournment to this is the first pretrial. I'd like another pretrial, and I want to communicate with the prosecutor in the meantime.
The court will continue a not guilty plea on behalf of Mr. Lagan. Set the matter for final pretrial conference. Court will set a final pretrial conference. Oh, Madam Clerk, I don't have it looks like I left my calendar on my desk, so I'm gonna need you to maybe pull up a little bit more, but a court is gonna set a final pretrial conference for Friday, October the 13th at 9:00 a.m. Discovery should be submitted by September the 13th. Bond will continue with no contact with the complaining witness and anything further.
Yeah, Your Honor, if we do have a resolution prior to October 13th, would we be able to get on your docket?
No. If there's a resolution, it'll be resolved on October 13th.
Okay, and there is no date that's sooner. I don't know that we need that much.
I said no. I need that much time. I need that much time. This is the court's docket. I need that much time. And the people are going to get.
And there it is, October 13th, marked in stone. Notice how the judge shuts down the idea of resolving the case early? That's not her being stubborn, it's her enforcing courtroom procedure. She makes it clear, this is my docket, my timeline. If you've ever wondered why cases sometimes feel like they drag on forever, here's your answer. Court scheduling is like a giant puzzle, and moving one piece can mess up the whole picture. But here's the kicker, the lawyer pushes again, and the judge doesn't budge. This is a masterclass in judicial authority. What do you think? Was the lawyer out of line for pushing twice, or just doing their job?
2 months to get the discovery to you. And then my docket says October the 13th.
Okay, thank you, Your Honor.
Okay, and then in the future, counsel, when I answer a question, the first time, I answered the question. You keep asking me again.
As you can see,
I'm sorry, Your Honor, I don't mean
the more you fuck
to
around,
be
Okay.
disrespectful
the
to
more
the
you're
court.
gonna find
I've never
out.
been in front of this court before, so I
So
apologize if I've offended the court in any way.
you didn't offend me. You didn't offend me. I'm bringing it to your attention. You didn't offend me. I said, no, you couldn't come early. Then you said, are you sure? That's basically what you said. Are you sure? I'm not offended. I'm just letting you know.
Okay, thank you, Your Honor.
Okay. All right. Anything further for the record?
Not from the people, Judge. Thank you.
Nothing further, Your Honor.
Okay, then we're all set until October 13th at 9:00 a.m. Have a great day and stay safe.
Thank you, Your Honor. You too.
You're welcome. Thank you. All right.
Now we shift gears to Mr. McCrary, and things get strange. He insists his name should be written in lowercase, not uppercase. At first glance, that might sound harmless, but this is a classic sovereign citizen move. These defendants argue that capitalization, contracts, or wordplay somehow change legal authority. Judges, of course, don't buy it. Already, we see where this is going. McCrary wants to debate ideology, while the judge wants to handle facts and procedure. This mismatch sets the stage for a clash, and spoiler alert, it's only going to get messier.
I don't know how this stuff works. I'm new to this, so I'm 50.
Okay, well, sir, hold on now. Are you okay? And Mr. McCrary, your name?
Ernell Michael McCreary, ill, all lowercase, not the all caps corporation.
Nobody writes the name in all caps. All right. So today is the date set for a pretrial conference. And Mr. McCrary, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McCrary, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
I would like to challenge the plenary jurisdiction of this court as outlined by state Supreme Court.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know as it relates to this pretrial conference where you've indicated that you want to represent yourself. It is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court.
You're going to be restrained every time you go off course. So
well,
understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCrary, as it relates to the pre-trial conference, how do you wish to proceed?
And here it is, the bombshell moment. McCrary formally asks the judge to recuse herself, citing judicial bias. Now, legally speaking, a judge can be removed if there's a legitimate conflict of interest, say, financial ties or personal connections. But here, McCrary offers no real evidence, just his personal belief that the court is biased. The judge denies it immediately, as expected, and kicks it up to the chief judge. Notice how she stays calm, even as McCrary challenges her authority. This isn't just legal drama, it's a defendant testing the system. Question for you, do you think he's genuinely convinced the judge is biased, or is this just a delay tactic?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And once this
motion is denied, anything further?
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor. code of judicial conduct, Judge. And I
I've
haven't
been
been
doing this for 16 years. I know what I'm supposed to do. So, Mr.
I said,
McQuarrie,
go.
I'm addressing, Mr. McQuarrie, I'm
Yes,
addressing
ma'am.
your request on the
Okay.
recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay. The
Thank you.
rule matters. You sent me
Okay, thank
beforehand.
you, Mr. McQuarrie. Thank you, Mr. McQuarrie.
Yes, ma'am.
Your Honor,
Yes, sir.
they indicated that he would need to file a motion for recusal before you. And if you deny that, it then goes to the chief judge.
He already
Well,
did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion.
Correct.
He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is no?
Sir, if you just, I promise you, I've been on the bench for 16 years. And I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
Oh, can I speak or no?
Oh, well, what else is there, Mr. McQuarrie?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McQuarrie.
Did you catch that? The judge actually tells McQuarrie he should have watched her courtroom on YouTube to understand how things work. That's rare. Judges don't usually drop self-references like that. But here, it's both a flex and a warning. She's handled hundreds of old cases. She's not about to let theatrics slow this one down. McQuarrie keeps trying to make it personal, but the judge is crystal clear. I don't take things personal. This is professionalism versus provocation, and the tension is off the charts.
I don't take things personally. Ms. McQuarrie, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And
correct.
Maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed. And so I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm gonna assume that this matter, as it relates to the pretrial conference for Mr. McQuarrie, is concluded.
And just like that, the gavel comes down. Case adjourned, for now. Let's break it down. Mr. Logan's case is on hold until October 13th, with deadlines locked in tight. Meanwhile, Mr. McQuarrie's self-representation strategy backfired spectacularly. His request for judicial recusal was denied, and now it's in the chief judge's hands. The big takeaway? Judges run the courtroom, not defendants, and trying to out-argue the system rarely works. But what do you think? Was McQuarrie standing up for himself, or just making things worse? Let us know in the comments. And hey, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay safe and stay sharp.